from the preliminary conference to the pretrial conference. We're bookending a significant part of the case. So there's going to be your legal documents that bring you to court. So litigation documents, one side suing another. Let's use divorce. There's going to be a plaintiff. That person alleges grounds or a reason for a divorce. The other side replies with a document called an answer. I didn't do it. That wasn't me. I don't consent. And then there should be some negotiation without court dates. Letters between counsel, telephone calls, emails, perhaps some proposed resolution. And some cases end there. A settlement is reached. A written stipulation is prepared, submitted to the court, order and judgment, signed over. And other cases do not end there. They ramp up. One side has to request a preliminary conference. The preliminary conference is getting the lay of the land before the court. What issues exist? Like there's a sort of a fill-in-the-blanks legal court form, grounds, you write them in, and counsel's names and addresses, and where retainer agreements submitted, where statements of net worth submitted, right? And the court will ask you a series of things. Are there children? And what can be narrowed down? And then what will each side ask for in terms of discovery? Depositions, EBTs, written interrogatories, discovery and inspection, a range of discovery tools, some disclosures, trading of different authorizations. Then there'll be some other conferences, a compliance conference, and then a trial date can be set. And, we're months into it, or a year into it, or 2 years into it, depending on the speed of the court and the circumstances. And once you set a trial date, they'll back into a pretrial conference. At that pretrial conference, again, depending on the judge, you may have to have your trial notebook. You may have to have all of your exhibits. You might have to exchange documents. And that's where we are. Cases can settle at the pre-trial conference. Why? Because you might have the opportunity to see some information that you had not previously seen. Let's say you knew that there was some type of asset, but because of different reasons, the value of that asset wasn't fully disclosed, or you were just made aware of it. And so if you saw the numbers, or it's a pension, and it had gotten evaluated, and there are different asset classes, different methodologies to split or divide what exists. And you may be able to do that. And if you do it, you never need the trial, and you'll go to an inquest instead. I just simplified the entire divorce process. The Oscar goes to Frank Bruno for Best Video Explanation of a Legal Topic. That's true. I was in court today several times. I had a conference in surrogates court concerning the settlement of a contested issue. Well, it was about the contested issue, but there were settlement talks. The way it works is that a law secretary, that's an attorney that works for the surrogate. The surrogate is the judge that presides over the probate court, right? It's the surrogate court, surrogates court. And that handles issues related to administration and probate. So we conferenced it. Then we conferenced with the surrogate directly. And the surrogate, where appropriate, pokes a hole in your argument or tests the metal of your theory and says, what about this? Or how about that? Or how about this evidence issue that you might have? I don't really think that the theory of your case is going to hold water, right? So these are the type of things. And so the surrogate would say that to one attorney advancing a theory, and then say that to the other attorney, that's at odds with that, with the other attorney, right? So the attorneys are in a legal battle over an aspect of the case, and the surrogate is looking to, and all judges do this, find the weakness in each side's argument so that ultimately you can arrive at a settled resolution rather than a trial. I am certain the surrogate and judges are able and available to preside over a trial. But whenever possible, settlement is appreciated and promoted. Why? Well, for a variety of reasons. But at the very least, in a settlement, both sides can be unhappy. Listen, in a decision by a judge or a surrogate, both sides can be unhappy. But in a settlement, you're unhappy with a term that you can live with, right? So you think you're entitled to this amount of money. In a settlement, you may accept less than that, but it's an acceptable amount. Whereas the decision after a hearing or a trial could be much less. Maybe you get 0. Maybe you get 25% of what you're requesting. So that's why a stipulated settlement arrangement is often promoted by all jurists. these are things that you can live with. Because some aspect of the case may be very important to you that would not really come across during the trial, and perhaps the judge would not, give that little boon to you, and therefore it's best for you to. So that's the takeaway. So, and the other case that I was on today was a guardianship matter where there were an already adjudicated guardian and a person went to live in the guardian's home. There was no order. So I will discuss that case in another video. Remember, I got the Oscar for, not this video because it didn't air yet, although this will be in the running for next year. I got an Oscar for work done earlier this year. Yes, and I want to thank the Academy. If you'd like me to simplify it for you, please reach out. Frank Bruno Law.